Thank you, General. I just have a question on the major questions doctrine, and I want just a little bit background for why I want to get your views on how it applies. You're arguing here that no notice and comment proceeding was required before the action taken on the $500 billion of loans, and that because of your view that the President can act unilaterally, that there was no role for Congress to play in this either. And at least in this case, given your view of standing, there's no role for us to play in this either. Now, we take very seriously the idea of separation of powers, and that power should be divided to prevent its abuse. And there are many procedural niceties that have to be followed for the same purpose. The case reminds me of the one we had a few years ago under a different administration, where the administration tried, acting on its own, to cancel the Dreamers program. And we blocked that effort. And I just wonder, given the posture of the case and given our historic concern about separation of powers, you would recognize at least that this is a case that presents extraordinarily serious, important issues about the role of Congress and about the role that we should exercise in scrutinizing that. Significant enough that the major questions doctrine ought to be considered implicated?
Well, Mr. Chief Justice, let me try to respond to the concerns about both the role for the judiciary and the role for Congress here. We are not suggesting that there's no role for the judiciary to play. It's that these plaintiffs are not proper plaintiffs in this case. Of course, the court is bound by Article 3, and as I acknowledged to Justice Alito, we think that loan servicers, for example, would have standing to challenge this plan. But the fact that the loan servicers haven't yet challenged to date doesn't provide a basis to overlook those fundamental Article 3 requirements and distort the meaning of how this court has previously articulated standing principles in a circumstance where the states can't otherwise demonstrate their standing to sue. With respect to the role for Congress, I think what's clear is, of course, we're recognizing that Congress could take additional action if it disapproves this plan. In fact, there were bills introduced to alter the text of the HEROES Act to specifically provide that the Secretary can't authorize loan discharge. Those bills didn't pass, but that's one role Congress can play. I think, though, that if the court is focused on trying to ensure that Congress's role in this process is respected, that just argues in favor of reading this text in line with what the plain language suggests. You know, these are not words of limitation in the actual assertion of authority here. Waive or modify any Title IV provision. The states want this court to say Congress really only meant waive or modify some of the provisions, not all of them, not the central provisions that govern repayment and cancellation, when those would have been obvious candidates for waiver or modification in a loan discharge program. And if the court overrides that clear HEROES Act language here, I think that it could only thwart Congress's intent in this particular posture of ensuring that you have the tools, the Secretary has the tools he needs to take care of Americans in a national emergency situation.
Well, whether Congress acted or not was a factor that we considered in the major questions doctrine. And the way we considered it is whether or not the issue that was before the court is something that had been seriously considered and debated and was a matter of political controversy before Congress. That certainly is the case here, right?
That's right. We're not disputing that this is a politically significant action. But if you're
not just a politically significant action, but one that has the attention of Congress. The fact that it hasn't acted under the major questions doctrine, but has considered the matter, we cited as support for the notion that maybe it should be one for Congress. If you're talking about this in the abstract, I think most casual observers would say if you're going to give up that much amount of money, if you're going to affect the obligations of that many Americans on a subject that's of great controversy, they would think that's something for Congress to act on. And if they haven't acted on it, then maybe that's a good lesson to say for the President or the administrative bureaucracy that maybe that's not something they should undertake on their own.
Well, let me react to that in a couple of different ways, Mr. Chief Justice. First is to emphasize that the unenacted legislation that the states are pointing to here did not mirror the particulars of this plan. So I don't think it would be right to say that Congress has specifically focused on this plan and disapproved it. And if the court were to go down that road, I'd point again to the fact that there's legislative inaction on the other side of not amending the HEROES Act. But I would think that the court, as it usually does, would place more focus on enacted legislation. And here, during the pandemic, Congress enacted a provision of the American Rescue Plan that specifically anticipated and sought to facilitate a program of loan discharge by providing that it wouldn't be subject to federal taxation from 2021 to 2025. So I think that that congressional action actually carries more weight in the analysis.